Well, good evening, everyone, and welcome to a Garden Court Chambers housing team webinar. This is a session on defences to Section 21 possession claims. We're going to hear from two speakers who are both going to cover various aspects of this very important issue in housing law. Just a couple of housekeeping points before we kick off properly. Just as a reminder, the session is being recorded. And both the recording and the slides are going to get sent out afterwards to everybody who is logged in. And in terms of questions, you should hopefully be able to see a Q&A option if you hover over the main screen on your Zoom page, and you can enter questions using that function there, or alternatively. After the speakers are finished, if you want to ask a question verbally rather than typing it, if you use the raise hand function, I will do my best to pick up on as many of them as we can and see if we can bring people in to the discussion afterwards as well. But you've got the option of putting written questions in the Q&A if you would prefer. So without further ado, I think we'll jump straight into our first speaker, which is Kevin Gannon, who's a very experienced member of the housing team here at Garden Court Chambers. Who covers the full range of housing law and homelessness issues. He's going to deliver the first half of the session on defences to Section 21 possession claims. So I'm going to mute myself now and hand over to Kevin, who's going to kick us off.
There we are. I should be unmuted now. Am I unmuted, Matt? Matt is smiling, so that is a good sign. Okay, well, thanks very much, everybody, for joining us on this session tonight. We're going to be dealing with defences to Section 21 possession claims, recent developments. It's a big topic, and of course, Section 21 claims form a large part of possession work. And as possession claims start to come back after the pandemic restrictions, I think we can expect Section 21 cases to be at least as prevalent when cases come back as they were before. So we're going to look in this seminar at some recent developments in the field. Angrad is going to look at more detail on notice requirements, the effect of the Tenant Fees Act 2019, and the latest on the proposals to abolish Section 21. In my part of the seminar, I'm going to look at some recent case law relevant to Section 21 claims. I will just mention the areas where defences to Section 21 claims are to be found, and then tell you the cases that I'm going to be covering. And then one by one, we'll go through the various cases. Matt, if you could go on to the next slide, please. So Section 21 defences have ballooned over the years. And I was reflecting as I prepared this seminar, what it was like when the Housing Act 88 first came in. And of course, short-hold tenancies were not even the default tenancy at that initial point. But as you can see from that list, the possible defences that might arise in a Section 21 case have ballooned over the years. There have been amendments to Section 21, new Sections 21A and 21C have been added. And there is other law also that gives rise to possible restrictions on landlords being able to give Section 21 notice. There's a list of some of those restrictions, and depending on who the landlord is in a given case, there might also be public law defences and there might also be defences under the Equality Act. Now, in covering the recent case law, and I'm talking about case law that's come up in about the last 2 years or so, the areas that I'm going to cover from that list of defences are inevitably going to be dictated by what cases there have been. And those cases do not cover all of the areas on that list. So the areas that we're going to be looking at as far as recent case law is concerned is the Section 21 notice itself, number 2, deposit protection, and number 3, compliance with prescribed requirements. And Matt, if you could go on to the next slide, please. Those are the 3 areas we're going to cover. So, and again, Matt, next slide. Now, there are 2 cases we're going to look at under section on the Section 21 notice itself. Not all of the cases that I'm going to cover are going to be detailed consideration. I'm going to spend a bit of time in this section on the Northwood case, and then the second one will be a much briefer mention. So, Matt, if you can go to the next slide, please. So this case, Northwood Solihull Limited and Fern and others, is about the formalities of the signing or the executing of notices where the landlord and or the agent are companies. Do notices have to be executed in accordance with Section 44 Companies Act 2006? Now, this case did not actually involve a possession claim under Section 21, but it did involve an assured short-hold tenancy, and it considered the formalities required for a notice seeking possession under Section 8, because that was the notice that was used in that case, and also for a deposit protection certificate when the landlord is a limited company. The issues considered in the case, however, will be relevant for Section 21 claims. So what happened in this case is that the claimant granted an assured short-hold tenancy to the defendant. A deposit was paid, certificate was provided, and that was signed by a director of the landlord company. The case report is interesting in that the law report actually uses a facsimile copy of the signatures on the deposit protection certificate and on the Section 8 notice. So when you read the report, if you need to, you can see exactly how the notices were signed and what the case is therefore talking about. So after a while, arrears arose and a Section 8 notice was served, relying on grounds 8, 10 and 11. That notice was signed by the landlord's property manager. And on the notice, the property manager had deleted the words landlord's agent. And so she appeared to have signed as the landlord. The question for the court was whether the signing of the Section 8 notice and or the deposit protection certificate was required to comply with the formalities in the Companies Act 2006, Section 44. That requires 2 authorised signatories on a document executed by a company or a director to sign in the presence of a witness when a company has to execute the document. Now, the court dealt with each notice in turn, but in doing that, they referred to the case which you can see on the slide there called Hilme and Associates Limited against 20 Pembridge Villas. That was a leasehold case, but the court drew broader learning from what was said in the Hilme case. And as you can see, I'll put on the slide the broader principle that the court extracted from that case. And the court said the broader principle underlying the decision is, however, on the following lines. If the legislation in issue and context expressly requires a signature by the relevant person itself, there is no other way of a corporate person satisfying this requirement other than by way of the general law, which requires execution under section 36A or its successor, which is section 44 of the Companies Act. Now, in order to apply that principle to the circumstances of the case, the court had to go back to section 8 itself and see what the section said as to how that document was to be executed. And I haven't included these extracts in the slides, but just to go on a bit from what was said at paragraph 60. At paragraph 68, the court said, and this is about the section 8 issue, in my judgment, unlike the statutory provision in Hilmy, it is significant and indeed determinative that there is no corresponding express requirement under section 8 of the 1988 Act that the notice seeking possession be signed by, quote unquote, the landlord by whom it is given. Further, the relevant prescribed form, number 3, expressly contemplates the notice being signed on behalf of a landlord by its agent. And a further passage at paragraph 71, the court said, in short, in the absence of any express statutory requirement that the notice be signed by, quote unquote, the landlord, it could be and was validly signed on behalf of the landlord by an authorised signatory without the need to comply with section 44 of the Companies Act. So on that basis, the section 8 notice was not effective. The court then turned to the deposit protection certificate, and in dealing with this aspect, again, just as they did with the section 8 aspect, they went back to the legislation to see what that said about how the document in question was to be executed, and the place to find that as far as the deposit protection certificate is concerned is in the tenancy deposits prescribed information order, which, as you'll perhaps remember if you've ever looked at that order, under Article 2.1, there's a long list of information that the prescribed information is required to contain. And that long list also includes the means by which that information is to be confirmed by whoever provides it. And it says under subparagraph 7, confirmation in the form of a certificate signed by the landlord that the information he provides under this subparagraph is accurate to the best of his knowledge and belief. And again, the DPC had been signed by a director of the landlord company, but not in the way that section 44 required it to be. The question was, given that that's what the legislation required, did it need to be signed in accordance with section 44? And as I've said, they extracted this principle from the Hilmy case and applied it to the DPC just as they did to section 8. And they said, paragraph 86, in my judgment, as in Hilmy, there is a legislative requirement that the notice stroke certificate be signed by, quote unquote, the party serving the document. The reasoning in that case to the effect that if a document is to be signed by a company for some legal purpose, then section 44 of the Companies Act prescribes how a company can itself sign such a document is clearly applicable. And then in paragraph 87, they said, and I'll paraphrase, that the certificate had a particular legal purpose, that the information was accurate to the best of the landlord's knowledge and belief. There was clearly a legislative decision made to impose some formality as to who must sign in this context. And therefore, the outcome of that was that the Section 8 notice was valid, but the DPC was invalid. And so the penalty awarded at first instance could stand. Next slide, please, Matt. Now, although Northwood and Solihull wasn't a possession claim, as I said, the issues that it explores are clearly relevant to Section 21 possession claims, and there is one directly on point. You can see the name of it on the slide, Bally and Manukau. The tenant in the case was represented by Nick Bano from Chambers. And again, the argument in that case was based on the Hilmi decision. The deposit protection certificate had been signed with the name Manukau, and then there was a PP underneath that with illegible initials. And the judge, His Honour Judge Han QC, based his decision on the Hilmi case. He held that the DPC was required to comply with Section 44, and the DPC was therefore invalid, so that the landlord could not rely on it. The possession claim was dismissed. That case predated the Northwood case, and in fact the Northwood case refers to it with approval in the course of the judgment. There's a slight complication to the decision in the Northwood case, because the prescribed information order, the order that relates to the deposit protection certificate and the requirements, was amended by the Deregulation Act to allow the initial agent to sign the DPC if it was the agent that protected the deposit. The effect of that amendment was not discussed in the Northwood case, so there's a little bit of uncertainty, but it probably still means that the Hilmi analysis applies, so that if either the landlord or the agent was a company and they're signing the DPC, the signing must comply with Section 44 in order for it to be valid. So that's Northwood, Solihull and Fern, and I think we can go on to the next slide now, Matt. So we're still on Section 1, the notice itself, and so we are jumping around in terms of subject matter within this section, but that's because I'm having to relate the areas on which cases have been decided. So this case is not at all on the formalities relation to the Companies Act. This is on a separate matter, but still in relation to the Section 21 notice itself. This was a County Court decision on the 30th of August 2019. And there's a note about it on Nearly Legal on the 6th of October 2019. And this relates to Section 21, subparagraph 4D, and I've set it out on the slide. Basically, the landlord has got 6 months to start a possession claim in summary terms once the Section 21 notice is served. That was a Deregulation Act amendment to Section 21, and I'm sure many of you will know that it was a common practice in the past for landlords to serve Section 21 notices at the outset of the tenancy, and this amendment, if that happens in a case, is going to be cause a problem for landlords in cases where that has happened. In this case, the tenancy was granted on the 20th of June 2011. Section 21 notice served the same day. Tenancy became statutory periodic, and then possession proceedings were commenced in 2019. First instance possession order was made. On appeal, the judge held that Section 41(3) of the Deregulation Act, where the amendment came from, applied straightforwardly, and was in force for all ASTs from the 1st of October 2018. Proceedings cannot be begun more than 6 months from the date of the service of the Section 21 notice, or 4 months after expiry of the notice period. Possession claim was dismissed. There are some other cases on a separate area of Section 21 where you will see that the 1st of October 2018 date leads to less straightforward considerations. But as far as this particular amendment was concerned, subparagraph 4D, it applied straightforwardly, and the possession claim in that case was therefore dismissed. Okay, so those are a couple of cases on the notice itself. Next slide, please, Matt. I'm going to go on to deposit protection. These are the cases that we're going to consider. The B, C, and D are fairly, we will deal with fairly shortly. Matt could probably talk to us, could definitely talk to us more effectively about Gul and Bilal, because that was his case, but that's one of the ones I'm going to cover in short form. The first case I'm going to cover in a little bit more detail. So next slide, please, Matt. Sturgis and Gupta against Body. So we're looking now at issues that arise in relation to deposit protection, because obviously that is because of Section 215 Housing Act 2004. If the deposit is not protected or the prescribed information is not provided, then there's a defence to the landlord relying on a Section 21 notice in Section 215. So that's why deposit protection is relevant for Section 21 defences. This case, I'm sure, will come to be known as the churn case. What happened in this case is you get occupiers initially, A, B, C, and D, as they're called in the judgment, and between them, they pay the deposit to the landlord. But over time, the occupiers change. First of all, one of them leaves and a new occupier comes in. So D leaves, E comes in. They make their own arrangement as to what to do about the deposit. So the likelihood is that D will want his or her share of what they paid towards the deposit returned to them. And if the tenants are making their own arrangements about that, then they'll require an incoming sharer to repay D his or her share of the deposit. And so E moves in, having done that, not with any reference to the landlord. And that process is called a churn. And then multiple churns occur in shared accommodation. And ultimately, you probably get to the situation where you have 4 occupiers, none of whom were the same as the original 4 occupiers. The first defendant in this case was the owner of the property. He let premises on an assured short-hold tenancy to 4 tenants and took a deposit. The tenants made individual arrangements as to how they dealt with their share of the deposit. And by the time of this particular case, which was a claim for a penalty payment under Section 214, none of the original tenants remained. The claim was brought by 2 tenants who had occupied the property, but they had since moved out. They sought penalty payments against the landlord for failing to protect their deposit at the time that they took up occupation. The deposit had never been protected by the landlord. They argued that at each churn, there was a surrender of the tenancy and the grant of a new AST to the new set of occupiers, requiring new protection of the deposit by the landlord. Judge Luber QC dealt with the case on appeal. He found that on each churn, each churn did amount to a surrender and re-grant. However, that of itself was not sufficient for the claimants to succeed. They still had to demonstrate that they either paid or are to be treating as having paid a deposit to the landlord. None of the occupiers, except the original 4, had ever paid a deposit direct to the landlord. And as I said, they'd made their own arrangements as to reimbursing their co-sharers as they moved in and out of the property. So super strike, of course, is the case on the question of occupiers, of landlords receiving deposits in this sort of situation. Judge Luber considered super strike, and then he said that paragraph 80, it seems to me that where the landlord has entered into a construct by which at his own design there is a single initial payment of a deposit and thereafter a churning in the identities of tenants, he must be treated as having been paid by each new cohort the amount held in respect of the original cohort and each subsequent cohort. So the obligation on the landlord was to protect the deposit on each churn. And in this particular case, the deposit at the time of the churns that the court was concerned with was £1,205. And Judge Luber said the case was right at the bottom end of culpability for the landlord. 1 times the deposit was the appropriate multiplier, but the judgment for each claimant was 3,615, 3 times, because each claimant had been involved in 3 churns, which had each produced a new tenancy. And as I said, this case didn't actually involve a possession claim by the landlord, but had it done so, the landlord's reliance on a Section 21 notice could have been invalidated by the failure to protect the deposit on each churn. The next 2 cases are also examples of multiple penalties under Section 214 Housing Act 2004. Next slide, please, Matt. Howard and Dalton. I've not put the case reference on this slide, but just to remind you, it is on one of the previous slides. This was a county court decision in Dartford, 7th of May 2019. There's a nearly legal note about it on the 3rd of June 2019. Howard and Dalton is remarkable for the fact that the initial deposit was £900, but at first instance, by the time the district judge had multiplied the number of breaches that he or she found the landlord to have been guilty of, and the multiplier of the deposit, the total judgment at first instance was over £83,000. This is how it happened. Tenancy began in 2007. Deposit of £900 was paid. There was a further payment thereafter of £845. A further 7 tenancies followed that initial grant. The deposit was not protected on any occasion. Tenant brought a claim alleging failure to protect the deposit and to provide the prescribed information. Landlord didn't attend the trial. The district judge held that the deposit sum was the total of the £900 paid initially plus the later £845. That was a total of £1,745. There was a breach in respect of each occasion of non-compliance, and that was 8 failures to protect, 8 failures to provide the prescribed information, and the penalty for each failure should be 3 times the deposit. And by the time you multiply all those numbers together, you get £83,760. Perhaps unsurprisingly, the landlord appealed that judgment. Circuit judge held that Section 213 envisaged a penalty for either failure to protect the deposit or provide the prescribed information, but not both. However, the penalty could be imposed for each tenancy. The judge accepted that the landlord could rely on a Limitation Act defence that was raised in that case. Obviously, some cases that may not apply, but it did in that case, and that reduced the number of tenancies involved to 4. He also regarded the 845 later payment as rent and advance, not deposit, and he also reduced the multiplier from 3 times to 2 times, so that ultimately the penalty was reduced from 83,760 to 7,200. And then another multiple breach case was the Liu and Sohal case, and reasonably straightforwardly here, the deposit was protected, but the prescribed information was not provided on the original tenancy or 2 subsequent renewals. Penalty, 2 times deposit on 3 occasions. And again, I've put the reference of that case on an earlier slide. It was a County Court Central London case in January 2019. And just a note there to remember Section 215A and B, Housing Act 2004. Those sections relate to the situation where you've got the same landlord and tenant. Once the deposit is protected and the prescribed information is served properly, the landlord doesn't need to do it again on each renewal. And the problem in the multiple penalty cases that I've just described is that it wasn't done properly the first time, and that's why multiple penalties were able to be awarded by the court. Next slide, please, Matt. Now, this case, as I said, Matt represented the tenant here, but it relates to the provision in Section 215(2)A, because the penalty of not being able to rely on a Section 21 notice if the deposit's not protected or if the prescribed information is not provided is made subject to subsection 2A. And one of the things that subsection 2A says is that if the landlord has returned the deposit, then those sanctions do not apply. But that raises the question of what amounts to a return of the deposit. And what happened in Gul and Bilal was the landlord left a cheque for the deposit at the premises. Tenant didn't want the deposit returned. He had not accepted the cheque and had never cashed it. And in those circumstances, the judge accepted the argument that the deposit had not been returned. There are other cases on what amounts to a return of deposit. And if you look at the nearly legal note in relation to Matt's case on the 2nd of November 2021, you'll see a discussion there about other cases that relate to what can amount to the return of the deposit. Okay, thanks. On to the next one, please. So last section of the 3 that I'm going to deal with on the recent case law are this section is compliance with prescribed requirements. And as you'll remember, Section 21, following amendment by the Deregulation Act 2015, there is a requirement for the landlord to provide gas safety certificate, an energy performance certificate, and the how to rent leaflet. And those are what is meant by the prescribed requirements. And these two cases both concern prescribed requirements. Trecarrell and Rounsfield is the one about the gas safety certificate, and Minister and Hathaway is about, as it happens, the energy performance certificate, but it raises wider issues as to in what circumstances a defence based on non-compliance with prescribed requirements can be raised in a Section 21 case. So next slide, please, Matt. So we're looking now then at this first case of Trecarrell and Rounsfield, and you'll perhaps remember that there's been a certain amount of litigation about gas safety certificates, and in particular there has been a degree of difficulty in the question about whether in particular the failure of the landlord to provide a valid gas safety certificate that's valid at the original date of occupation. If the landlord doesn't provide that when the tenant occupies the premises, is that a once and for all breach that can never be remedied? And therefore, is it a once and for all, is it a defence that will always apply in a Section 21 case? Now, the difficulty that arose and that led to this question about is it a once and for all breach, arose because of the interaction between the wording, particularly in Regulation 2.2 of the prescribed regulations and Regulation 36 of the gas safety regulations. So in the prescribed requirements regulations, the requirement is set out in Regulation 2.1b, but then we've got Regulation 2.2, which says, for the purposes of Section 21A of the Act, that's the section that deals with the requirement to comply with prescribed requirements, the requirement prescribed by paragraph 1b is limited to the requirement on a landlord to give a copy of the relevant record to the tenant, and the 28-day period for compliance with that requirement does not apply. Now, from what I've said and from what's on the slide, you can't really see what the nature of the confusion was between Regulation 2.2 and Regulation 36 of the gas safety regulations, but I don't think there's time to go into that in detail. Much better, I think, to spend the time on describing how the conclusion that the court came to when it sought to resolve that confusion. You'll know that the situation was considered before the Trecarrell case by His Honour Judge Luber QC in the case of Carridon Property and Schultz, and Judge Luber held that the requirement in Reg 36.6 of the gas safety regulations should be strictly applied, and that later service of the relevant gas safety certificate was insufficient to free the landlord from the embargo on service of a Section 21 notice. In other words, it was a once and for all obligation that could not be corrected later. Trecarrell and Rounsfield, in that case, it was appealed initially to a circuit judge who followed Judge Luber's decision. Landlord then appealed, and the Court of Appeal therefore considered the position and also considered whether they agreed with what Judge Luber had said. And as you can see, I've set out what Lord Justice Patel said at paragraph 30. As a matter of construction, I prefer the view that as a result of Regulation 2.2, the time when the landlord is in breach of paragraph 6b ends for the purposes of section 21A once the gas safety record is provided. And Lord or Lady Judge King agreed with that. There was another argument that was pursued on behalf of the tenant in that case, which was that even if the non-provision of the first gas safety certificate was cured by its later provision, the second inspection had occurred more than 12 months after the first one. That argument was rejected on the basis that the 12-month requirement was not itself a prescribed requirement. So the position after Trecarroll, not entirely clear. It's not an easy read, Trecarroll and Rounsfield, but what I think one can say is that after that, I think others might have differing views, but first of all, prescribed requirements only apply to tenancies, ASTs that began on or after 1/10/2015, and you'll see why that is in the next case, Minister and Hathaway. The timing difficulty with gas safety certificates, because it's created by Regulation 2.2, only applied to gas safety certificates, not EPCs. And I think what the Court of Appeal is saying is that the gas safety certificate that was valid at the time when the tenant took up occupation has to be given before the Section 21 notice can be served, and the current gas safety certificate, if that's a different certificate. I think it follows from that if there was no gas safety inspection at all, so that there was no valid gas safety certificate actually current at the time of the original occupation, that probably amounts to a once and for all breach that can't be cured. And the 12 months argument, although that's a breach of the gas safety regulations, is not a breach of the prescribed requirements. On to the next slide, please. Minister and Hathaway, I've well exceeded my allotted time, so I will deal with this one fairly briefly. And it's although that there is some elements of it that are on an initial view not straightforward, in the end it's I think reasonably clear. Landlord granted a tenancy in 2008, and then in 2018 Section 21 notice was served, not in dispute that no EPC had been served prior to that date. The proceedings that followed were defended on the basis that the landlord could not rely on the Section 21 notice in the absence of an EPC being given prior to the service of the Section 21 notice. The point, of course, was that on the face of it, you look at the statute, or if you look at the Deregulation Act amendments, what they said was that they apply to a tenancy that begins on or after 1/10/2015, and then after a period of 3 years, those amendments apply to all tenancies. So in other words, after 1/10/2018, the Deregulation Act amendment applied to all tenancies. And therefore, because the Section 21 notice was served after 1/10/2018, why didn't that just apply in this case? It was not in dispute, there was no EPC. But a careful reading of the statute and also the regulations reveals that what Section 21A is talking about is breach of prescribed requirements. And therefore, you have to go to the regulation to see what requirements are prescribed. And the prescribed requirement regulations only set out requirements for tenancies that begin on or after 1/10/2015, and that's never been changed. So it was not possible for the Section 21 claim to be defended on that basis. The provision of the How to Rent leaflet is also governed by the prescribed requirement regulation, so it would seem to follow that regulation also only applies to tenancies that begin on or after 1/10/2015. Thank you very much. That's the end of my section.
Great, thank you very much. Really, really useful overview of the different defences that might be available, or some of them anyway. For what it's worth, I've had a post Northwood Solihull type case involving an agent and the Companies Act. And the county court in that case was with us, that where the agency was the deposit holder, as described in the certificate, then the Companies Act provisions took effect for the agent as well. So it wasn't good enough for an employee of the agent to sign the certificate. It had to be in compliance with the Companies Act in that case. And the reason why we got into that was because, as I understand it, the Northwood Solihull and Fern case is going, or may have already gone, to the Court of Appeal. And in part because the judge in first instance didn't deal with the amendments brought in by the Deregulation Act. So it may be that we get some further development on that. But yeah, it'd be interesting to see if anybody else has any experience of that particular defence.
Yep.
Great. Well, thank you very much, Kevin.
Thanks,
I am going to hand over now to Ang Harrod, who is another member of the housing team at Garden Court. She's been a tenant here since October 2020 and has a busy practice in housing, community care and wider public law. And before joining Chambers, she was a paralegal at the Hackney Community Law Centre. And Ang Harrod also does a full range of housing, homelessness work, as well as possession and disrepair cases. So without further ado, I'm going to mute myself and hand over to Ang Harrod, who's going to take us through some other potential issues that might arise in defending Section 21 cases.
Thanks so much, Matt, and thank you, Kevin, for that very helpful summary of all the recent case law relating to Section 21. I'm hoping to be quite a bit quicker because I'm covering probably what's rather more straightforward subject area. Let me just try and get my slides up now. Great. So what I'm going to be covering is, first of all, I'm going to just run through some of the new provisions under the Tenant Fees Act and how the defences that arise to Section 21 under that Act. I'm then going to give a brief summary of some of the changing procedural requirements for Section 21 over the last 18 months or so, which is both the changes to the relevant notice periods during the coronavirus pandemic and also the recent changes to Form 6A. And then finally, I'm just going to give an update on the latest on the government's position in terms of the abolition of Section 21. So in terms of the Tenant Fees Act, first of all, this now applies to all private ASTs from the 1st of June 2020. I should highlight it does apply to some lettings that are not ASTs, but obviously for the purposes of today's seminar, it's just important to know that it will apply to all ASTs. And what the Tenant Fees Act does is it prohibits landlords and letting agents from charging any fees other than a list of fees which they are permitted to charge, and I've given a list of those here. So obviously they are allowed to charge rent, a tenancy deposit which can't now exceed, I think in the majority of cases it'll be 5 weeks rent, a holding deposit of up to 1 week's rent, a fee taken in the event of a relevant default. So this is essentially a fee levied if the tenant loses a key, or in certain circumstances they're permitted to take a limited penalty for failure to pay rent within 14 days of the due date. It should be noted as well, though, that there is a limitation on how much they can charge in respect of a penalty for late rent. Damages for breach of tenancy agreement, reasonable costs in connection with a tenant's request for variation assignment or novation of a tenancy. So that's going to apply in situations, for instance, where the tenant wishes to introduce a new tenant to the agreement. Losses suffered as a result of the termination of the tenancy at the tenant's request before the end of the term or without the required notice. So this won't apply in situations where the tenant has brought the tenancy to an end in accordance with their rights to do so under the tenancy agreement. And then payments in respect of council tax, utilities, communication services and TV licenses. In terms of the relevance of this to Section 21, this is contained in Section 17 of the Tenant Fees Act, which prohibits the landlord from serving a Section 21 notice in circumstances where they've required a relevant person to make a prohibited payment. So that's a payment other than those payments that I've just set out that they are permitted to levy. And as a result, that person has made one of those payments. So anybody who's made a prohibited payment to a landlord until such a time as that has been returned to them, a Section 21 notice can't be served. There is also a potential defence in terms of the landlord's failure to comply with requirements set out in the Schedule 2 of that Act, which relates to holding deposits. Essentially, that relates to the requirement that you offset or return the holding deposit once the tenancy is commenced. And yes, so this will apply. You can't serve a Section 21 notice until either you've repaid the prohibited payment. So in the cases of deposits that are in excess of the amount that's permitted, it's only the portion of that is in excess of what is permitted that's prohibited. So if, for instance, the landlord charged a two-month deposit, they then returned the excess to the tenant, they would then be permitted to serve a Section 21 notice. Or that payment's been applied either towards rent, the tenancy deposit, or a combination of the both of those. So, for instance, if the tenant had got into rent arrears and gave consent to the landlord to offset the additional prohibited portion of their excessive deposit, for instance, against the rent, then that would enable the landlord to serve a Section 21 notice. In terms of who a relevant person is, it's the tenant and anyone acting on their behalf or a guarantor, but it should be noted that it doesn't include a local authority. So in circumstances where the local authority may have paid the deposit, unfortunately, this defence wouldn't apply if that deposit was in excess of the permitted amount. Okay, so that's a brief overview of how the Tenant Fees Act is introducing defences to Section 21. I'm now going to very briefly run through some of the changes to the Section 21 notice regime over the last 18 months or so. I'm just, before I give, I've got a little table which is a reiteration of just the relevant notice periods that have applied during the various periods over the pandemic. In essence, that table is really just a reiteration of material that's available in a number of different sources online already. Nearly Legal has a brilliant Excel spreadsheet. Shelter, I think also the website has quite a good function where you can put in the relevant dates and it will tell you what the notice requirements were for the notice. So it's always worth checking just with one of those services online. But I'm just going to quickly run through how those changes have taken effect in terms of the law, so that you've got the references you need if this is a point that has to be raised. So at risk of teaching you all to suck eggs, I'm just going to quickly summarise how the notice requirements in Section 21 actually work. So in terms of, first of all, how much notice has to be given, there's two different scenarios. The first is that set out in Section 21, subsection 1 of the Housing Act 1988. And this is what applies to ASTs which were at any point a fixed term tenancy. So this is going to probably be the majority of cases. It includes statutory periodic tenancies that have arisen at the end of a fixed term as well. And essentially what it does is it gives a requirement for a minimum period of notice to be given at the end before proceedings can be commenced. Section 21(4) is a kind of mirror provision to Section 21(1), which applies to assured short-hold tenancies that were periodic from commencement. So this will be a situation where there was no fixed term and the initial tenancy that was entered into between the parties was periodic, and that requires a minimum notice period, and that also has to be given in such a way that it ends on the last day of a period of the tenancy. So, but in reality, the effect is very similar for both. Then, so in addition to that, we then have the provisions relating to the expiry of Section 21 notices, which, as Kevin set out, were Deregulation Act introductions to the Housing Act. There's one each of these provisions relating to both of the scenarios in terms of Section 21(1) and 21(4). What they do is essentially provide a maximum amount of time before the notice can then no longer be relied upon. They are phrased in a slightly different way in the vast majority of cases, assuming that a landlord will give the minimum amount of notice that they're entitled to do. The period will be the same. Then the way that the COVID changes to those notice periods and the expiry window for the Section 21s has been affected was primarily through paragraph 7 of Schedule 29 of the Coronavirus Act 2020. And what that does is just amends the time periods in each one of those provisions of Section 21. So that's subsections 1, 4, 4D and 4E during the relevant period. The relevant period began on the 26th of March 2020, which was the date that the Coronavirus Act came into effect. And the end date of that relevant period has changed on a number of occasions, because that was one of the provisions that's capable of amendment by statutory instrument. So both that and the notice periods themselves have been amended on a number of occasions, and I've set out all of the relevant pieces of secondary legislation here on this page. I'm not going to run through all of them, because the most important thing is that we all know what the actual time periods were in the relevant periods, and for that we've got a little table here. As I said, this is information that's easily available in a number of sources online. Both Shelter and Nearly Legal have got good tools for working out what the periods are that we're looking at. But essentially you can see that obviously before any of the changes were introduced, we had the 2-month notice period and the 6-month expiry. We're now back to that. We've come back because from the 1st of October 2021, there's no longer any amendments enforced to Section 21. The first amendment was the introduction of the 3-month notice period at the beginning of the pandemic on the 26th of March. That no amendments were actually made at that time to the expiry window, so that stayed at 6 months, so that the landlord effectively just had 1 month less in which to use their notice. Then on the 29th of August 2020, the notice period was then increased to 6 months, and they then also extended the expiry window to 10 months, so that a landlord actually was able to bring proceedings, because otherwise it would have been impossible. That was then reduced to the 4 months and 8-month expiry window on the 1st of June. And yes, now from the 1st of October, we're back to the situation as before the Coronavirus Act. Another thing just to note is that we've got a new Form 6A. It's been amended quite a few times over the coronavirus pandemic. It's been amended each time in line with the changes to the notice periods for obvious reasons. We've got a new one now from the 1st of October, which is actually in a slightly different form to the one that we're probably quite used to seeing now, in that they've removed a lot of the information that was contained within the notice about the minimum notice periods and expiry dates. There is now an accompanying guidance note, but it's not a statutory requirement for the landlord to serve that. They're only required to serve the new form 6A. This is it. So you can see it's quite a bit shorter than the form 6As that we've seen in the past. Okay, so by way of update on the abolition of Section 21, unfortunately, there's nothing particularly hopeful to share here. Obviously, we all know that this has been something that's been a Conservative Party commitment now since 2019. It's Theresa May's announcement on the 15th of April 2019 was when we first heard that this was going to be in the pipeline. It's been a Conservative Party commitment on a number of occasions since then. I've listed some of them here on this slide. In the Queen's speech in December 2019, it was explained that essentially this is going to come as part of a renters reform bill, which will include a number of other measures as well. What we're now waiting on is a white paper that we've been promised that is going to be the precursor to the renters reform bill. We had been promised to have that this year. There's been a recent announcement from the government that that white paper is not going to be happening now until 2022. So it doesn't seem like Section 21 is going anywhere anytime soon, unfortunately. There's just by way of another brief update, which I don't have a slide in relation to this, but as quite a few of you might be aware, the overall arrangements for possession proceedings has now ended. It ended on the 1st of November 2021. Doesn't make a huge amount of difference to Section 21 anyway, because obviously the overall arrangements in terms of the R and S dates never prevented the court from making possession orders on the papers under the accelerated procedure anyway. But that is now gone. In terms of what courts are actually going to do, it may be that there's now going to be quite a bit of regional variation because it's being left to local courts to essentially decide what their own procedure is going to be going forward in respect of the R&S dates. Practice Direction 55C is also now on its last legs. So we've, at the moment, it's going to apply going forward to possession claims which were issued before the 30th of November 2021. It's going to also apply to claims that were issued after that date, but only up until a date in June 2022. The provisions of that are relevant to Section 21 really is just the coronavirus notice. Everything else isn't really going to be relevant in Section 21 claims, apart from if we still had any stayed claims that were subject to reactivation, that could potentially apply as well. But it's seeming that as time goes on, less and less likely that there's going to be any reactivation of Section 21 claims now from the stay period. Yeah, that's my talk done. So I'll hand back to you now, Matt. Let me just mute myself.
Thank you very much. Really, really useful update and overview of the notice periods and of the Tenant Fees Act as well, which I think is still, I don't know, I've not had a huge amount of interaction with it in my own casework so far, but it'd be interesting to see if anybody else has had any experience in the discussion. So yeah, thank you both of you. Really, really useful overviews of the different issues that might arise in Section 21 cases. What I'm going to suggest we do now is see if we can have a little discussion going. And we've got a few questions for both of you in the Q&A section of the Zoom. And I think the first couple are sort of related to Kevin's presentation. So I'm going to ask you to have first dibs on trying to answer these ones, if that's all right, Kevin. So we've got a question on Sturgis and Gupta. And the query is how a new joint tenancy could be granted on each churn when the four unities weren't present because each tenant had arrived at a different time and where there's no joint tenancy agreement signed. I don't know if you're able to help us out with that one.
Okay, thanks. Well, I'll have a go. Yes, the discussion, I haven't got the judgment in front of me, I'm afraid, so I can't quote directly from it, but there is a discussion by Judge Luber in the judgment about whether the situation where one of the tenant leaves, another one comes, does actually amount to a new tenancy. And I don't recall the discussion being based on the existence of the four unities, but I have got a note which I think is not the full extent of the consideration that this issue was given by Judge Luber. But what he said on this issue was that he was considering about whether the departing of the outgoing tenant amounted to a surrender. And he said that the authorities on surrender are infused by the concept of estoppel, i.e. the landlord who has acted consistently with the termination of a tenancy and the acceptance of a new tenancy cannot later resile. In the current context, it would be absurd to think that the landlord could insist that an individual who was a joint tenant before a churn and had left after it was still a tenant, even though he was accepting rent he knew or can be taken to have known was being tendered on behalf of a new group. So as I said, I'm sorry, I don't have the judgment to hand. So I'm not sure that's the full extent of the discussion about that issue, but that is at least partly something of the way that Judge Luber dealt with that. And he dealt with it, as you can see there, by applying an analysis of estoppel and the absurdity of the situation of the landlord accepting rent from a new person. And it would be absurd to regard the original four tenants as still being the rent in the situation where he was still accepting rent from somebody new.
Okay, great, thank you. Brilliant. Okay, so I'm going to move on to the next question in the Q&A box, which is, does a tenancy that becomes a statutory or contractual periodic tenancy after the 1st of October 2015, is that treated as a new or a renewed tenancy, as it were? Because obviously that will have an impact on validity of Section 21 notices and so on. I don't know if either of you want to.
Well, I think that's Angharan can certainly come in if she wants to, but I think that sort of comes out from because this is relevant to the prescribed requirements. And as you remember, this was an issue both in the Minister and Hathaway case and also in the Trecarrell case, because it's the amendment to Section 21 that brings in the requirement to comply with prescribed requirements. And then there's the complication of the fact that those are then defined in the prescribed requirement regulations. Now, the prescribed requirement regulations does answer this question, I think, reasonably clearly, because in paragraph 1 of the regulations, it says, first of all, paragraph 1, subsection 3, these regulations apply in relation to an assured short-hold tenancy of a dwelling house in England granted on or after 1st of October 2015. So that's the basic position. And then subparagraph 4 is where the real answer to this question is. These regulations do not apply to an assured short-hold tenancy that came into being under Section 5.2 of the Housing Act 88, that's the statutory periodic section, on or after the 1st of October 2015, on the coming to an end of an assured short-hold tenancy that was granted before that date. So if the tenancy begins before 1/10/2015 and the statutory periodic begins after, then it's not covered by the prescribed requirement regulations.
Yeah. So it's a renewal as opposed to a new one, as opposed to like a fresh one, basically. Yeah, I think that makes sense. Okay, great. I think the next question is for Angharad, and that's from Rebecca. So the question is, if a tenant applies for a property, places a holding deposit, and then the tenant fails a reference process, such as a credit check, in that situation, is the landlord permitted to retain the holding deposit? So I guess this is in relation to Tenant Fees Act and whether that affects landlord's ability to then rely on a Section 21 notice later down the line. Do you have any thoughts on that one?
Yes, the short answer is no, they can't. So basically the way that Schedule 2 of the Tenant Fees Act 2019 works is that the landlord is only allowed to retain the holding deposit in 4 different circumstances, and that's where they don't have a right to rent in terms of their immigration status, that they provide false or misleading information. So long as they've complied with, if they've provided accurate information for their referencing process, then that one shouldn't be applicable in that circumstance. Or where they pull out of the application process, or where the tenant themselves doesn't take reasonable steps to enter into the tenancy agreement. So none of those would apply.
Okay, cool. And I think you said earlier as well that if a holding deposit is more than a week worth of rent anyway, then that would prohibit a landlord from relying on Section 21. So they wouldn't want to retain it. It wouldn't be in their interest to do so. Okay, great. Thank you. I think the next question is probably open to both of you. So from Rachel Lovell, if a tenant's bringing a counterclaim for failure to protect a tenancy deposit to a rent possession claim by a landlord, then regarding the limitation point that was raised in Howard and Dalton, which Kevin talked about earlier, is a deposit counterclaim under the Housing Act 2004 an equitable set-off to the rent arrears as a way of getting around the Limitation Act in the same way that you might do with a disrepair counterclaim? I don't know if you've any thoughts on that. So whether you can essentially be timed out of bringing such a counterclaim in relation to failing to protect a deposit.
Well, good question, Rachel. Basically, there is an extensive discussion about the right limitation period in the nearly legal note to the Howard and Dalton case dated 3/6/2019. And I don't, from my recollection, I don't believe it deals with this possibility. It arose in the Midland Heart and Idawa case because it was one of the reasons that I think the way it arose was that it was the landlord said that the tenant should not be allowed permission to bring a late counterclaim because it deprived the landlord of a limitation defence because it was an equitable set-off. And as Rachel said, there's a special provision in relation to equitable set-offs in Section 36(2) of the Limitation Act. That point wasn't really fully explored because in Idawa, I think that the court said it hadn't been raised at the first instance. So it wasn't a ground of appeal that the court needed to deal with. So yeah, that's all I can say. I haven't got the answer, I'm afraid. I can say that's an extremely interesting thought and up for grabs, I would have thought.
Yeah, just to come in on that, I think it's arguable, and I've argued it. So, yeah, go for it, I think.
Yeah, I would have thought so as well. My instinct would have been that I would have thought it would get around a limitation at that point in the same way that just a fair counsel claim might do. But yeah, interested to see how that goes. Thank you very much. I think we've got time for a couple more. So I'm just going to go through the list of the questions as they're coming up in order. So next question is, if a how to rent guide and by default an EPC and gas safety certificate is sent in the post with a Section 21 notice, not disputed that this is the first time it's provided to the tenant, has the landlord complied with the Deregulation Act 2015, and are they able to rely on a Section 21 notice? Happy to throw that open to either of you guys. What do you think in this situation? So it's sent with the Section 21 notice as opposed to prior. Does that count as compliance?
Again, a bit tricky, I think, to be definitive about that. Section 21A, subsection 1, a notice under subsection 1 or 4 of section 21 may not be given in relation to an assured short-hold tenancy at a time when the landlord is in breach of a prescribed requirement. So, if if the landlord's giving all these notices at the same time, then I suppose there is an argument that the notices, that the Section 21 notice is good if they're coming together. On the other hand, does that leave open the possibility of the tenant pulling out the Section 21 notice first, having never at that point seen the other notices? But if they all come on the same day, I don't know. Sorry, I can't. I've got a vague recollection that there was an old case under when Section 20 notice was required because if you remember when the Housing Act started, assured short-hold tenancies were not the default form of tenancy. They only became that form if a Section 20 notice was served. And I believe there was authority to say if you gave such a notice before the tenancy started, it was no good because you had to give it at the time to the tenant, and the tenant wasn't a tenant until they started to be a tenant. So it didn't count. But I don't know whether my recollection of that is entirely accurate or whether that's got any application. But I'm sorry, no definite answer to that question.
I mean, yeah, for what it's worth, I think if it was me, I'd be arguing that, it needs to be done prior to Section 21 notice being served, and that there needs to be some, the tenant is entitled to be aware of, whether the property is actually safe in terms of the gas safety, in terms of the EPC and all that. So I'd be arguing that it needs to be prior to service of Section 21, but
the safety argument was a very strong argument on which Judge Luber relied in the Schultz case originally. And although the Court of Appeal didn't uphold him, they recognised that the provision of the gas safety certificate was an extremely important requirement for tenancies. So that's something that you could certainly pray in aid in making that argument.
Great, thank you. All right, I think we've got time for a couple more questions. So I'm going to move on to the next one from Sarah, which is in respect to Minister and Halfway. Is there any possible argument that an agreement to increase the rent post 1st of October 2015 constitutes a new tenancy for the purposes of bringing in the prescribed requirement? So in other words, is this another way of trying to bring in those amendments from the Deregulation Act so that some of the defences to Section 21 might bite in such a situation? I don't know if Angharad wants to have a go at that one first. Any thoughts on that?
I would be arguing it if they've not properly increase the rent with the Section 13 notice, I'd be arguing that it's a new tenancy. That's the short of it.
Yeah, again, I would agree with that. You look at some of the multiple award cases that I discussed in the. I don't think this was an actual situation, but the courts have been, very ready to accept that new tenancies arise. Obviously, in those cases, that they did actually. Well, as far as one can tell from the brief reports that there are in some of the cases, they were actual new tenancies. But I mean, the chances are the only change in the grant of the new tenancy was a change in the rent. So I don't see why that isn't at least an argument that you could try.
Fair enough. Thanks very much. Both really helpful answers. Thank you. Okay, so we've got another question in the chat from Mike, who asks about Kevin's part of Kevin's talk about signatures on Section 21 notices. And the question is a typed signature rather than a written one? Does that give rise to any form of defence? And he mentions that Barker and Hans concluded that a notice doesn't have to be signed in order to be valid. But is there any development on that line of thinking?
Well, yeah, good question on that one. In fact, all of the notices that were discussed in the Solihull case, and the Hilmy, of course, wasn't a Section 21, but also in Nick's case, which was, none of them actually dealt with the Section 21 notice itself. And if you remember, the general approach that the court adopted in that case came from the leasehold case of Hilmy, where they extracted the broad principle. They then went away and looked at what the specific statutory section required as far as the execution, using that word in the broad sense, the production or the promulgation of the document, the providing of the document. What did the particular section require? Section 8 was worded in a way that didn't require it to be signed by quote unquote the landlord, and therefore the rigours of Section 44 didn't apply. The DPC was different because the prescribed information regs were different. So one would have to, the starting point is you'd have to look and see at what Section 21 actually says. Going on from that, whether the typing makes any difference or not, I don't know. You'd have to start off by working out if Section 44 applied. Sorry, can't give you a definitive one to that either.
I mean, I suppose in theory it could go both ways in terms of whether you might want to rely on a typed signature yourself. For example, if you're signing a statement of truth on your defence and counterclaim, or on a witness statement, obviously it's kind of more and more common for people to use sort of electronic versions of signing things. So I guess it could go both ways if that was something you really wanted to challenge. But yeah, I think in terms of the prescribed, in terms of the certificate for deposit protection, yeah, I wouldn't be surprised if more and more use is made of the potential defence that seems to be open under the Companies Act point. Okay, I think there's probably time for one more question, or at least a contribution. I'm going to skip to the contribution that Jensen's put in the chat, so slightly different area of the Zoom thing, just because it relates to a previous discussion that we were having. And the Jensen's contribution is whether the answer to the question about limitation periods that you can set off against a disrepair claim against rent arrears, and that is an equitable remedy, is the extent to which it's necessary to extinguish the arrears but then the excess amount, which might exceed the rent arrears, is a counterclaim, and therefore not a set-off, and therefore is subject to limitation, and whether the same might apply for a deposit protection case. So if the penalty that you're seeking for failing to protect a deposit exceeds what the rent arrears actually are, whether that has an impact on whether it's an equitable set-off or not.
Sorry, my view on it is that it does. I can't see how it works if the total award. I think you're only going to be able to rely on it to the extent that alongside other elements of your counterclaim, it doesn't extinguish the arrears. I think that would probably, in my view, extend to anything you might be pleading. So if you're pleading disrepair and other issues as well, you're probably only going to be able to get around the Limitation Act by equitable set-off to the extent that the rent arrears are so great that it's needed. But I don't know what Kevin might think about that.
Yeah, no, I see that, Angarad. I agree. I've got nothing to add. Okay,
lovely. Always good to end on a note of agreement. Well, I think that's probably a good time to wrap things up. Thank you very much, everybody, for your attention and for all the questions and comments and contributions. And thank you once again to Kevin and Harry for some really, really useful presentations, really useful points and refreshers and updates as well. Enjoy the rest of the evening. I'm going to end the meeting now, and the recording is going to stop. But the recording and the materials are both going to be sent out afterwards as well, so you can go back and relive it all. Thanks very much, everybody, and enjoy the rest of the evening.